Thank you to our Vice Chancellor for that very insightful discussion on various aspects of the amendments and the delightful sprinkling of anecdotes and quotations. Thank you very much, sir, for all the work, because we gave him last-minute notice that since we don't have a keynote address, he will have to speak a little more on the amendments. Can I now introduce Professor Gopalakrishnan, who was again given the arduous task of really providing a baseline for the discussions today. So what I requested of him was that to come in and give a macro perspective as well as a micro perspective on the amendments, the connecting thread through some of them, the underlying policy rationales, the various gaps, etc., etc. And he's best placed to do it because he's been one of the key advisors to the government for a number of years, including advising them also on the international negotiation position, as well as the amendments, and is best placed to really offer us a very, very key insights into this process of policy making, what it means, and where it's going to lead us from here. So with that, may I please welcome Professor Gopalakrishnan.
Thank you, Shamnad. Honorable Vice Chancellor of NUJS, Professor Ishwar Bhatt, Registrar Surjit, distinguished speakers. Let me, in the beginning, convey the greetings from my Vice Chancellor, Ramachandran Thakkedath, for inviting us to be co-sponsoring this project, this conference, and also from the CUSAT community for recognizing the chair at CUSAT as a good partner at the national level. Now, I at the outset thank also the students who took a lot of efforts. Shamnad was toying the idea of organizing at Cochin. I said nothing doing, because I know the limitations I have at Cochin in organizing things. The student community makes a lot of difference. I see quite a lot of hard work, and I profusely thank them for organizing it. My job is to some extent, throw open some critical issues which will facilitate subsequent sessions to take it up and develop further. I'm fortunate as a law teacher to be associated with this amendment for a long. Probably my association started from 1996. I was throughout in the committee, which really gave the full framework for this amendment. Even after the committee has been closed, there was a drafting committee. I could also associate with that. Even after the drafting committee was closed, the government was kind enough to keep me associated, probably because of the chair at CUSAT. What I'm going to do, is to look at the gaps and conflicts that reflect in the copyright amendment at the end of the day. What are the gaps which the law wants to cover, and what are the conflicts which the law really addressed? Then move on to the principles followed in balancing of interest. I put the balancing of interest in quote because I am very, very scary of this whole called balance, in which direction the balance goes. I look at the role played by the interest groups, because that's the politics of it. The first and second talks about economics and the social situations. The role played by the interest groups play the political part of it. Look at the missed opportunities very briefly, and then more look at the challenges of implementation. I'll be spending more time on the challenges of implementation rather than the other two. If you look at the gaps, it was really digital technology, particularly the late 90s and early 2000 or the period where the lawmakers or the bureaucracy was really pushed to look at digital technology. And we have quite a lot of things to look at on digital technology. One is to updating the rights of the author. A bit was done in 1992-94 amendment, but there was quite a lot of gaps. So this amendment was trying to address those gaps. Updating the rights of the user, this was completely neglected in 1992 amendment. While the 1992 amendment made quite a lot of interventions on updating the rights of the author, it was a big flop with reference to the user's right, particularly in the digital context. Protecting the interest of service providers is what again has been neglected, which got some attention in this amendment. That was also a gap which has been noticed. Technological protection measures, the moment you upgrade the rights to digital technology, there is also an issue of how the technology used to take care of the interest of the right holders needs to be addressed, which is also a gap which the law found when the amendments were taken. Access to works to persons with disabilities, which is a total vacuum which we had irrespective of the amendment, which was quite extensive. What I realized was there was no people to argue for them. Luckily, in early 2000, the professor from Delhi University, who is no more, was the one who initiated the process. I remember him appearing before the core group and making very, very passionate appeal to bring some provision inside. With a lot of resistance at the end, we had some light. Updating the rights of the performers, we had a provision on 1994 introduced on performers, which was largely in tune with the Rome, though we were not the member of Rome Convention. But then there was a gap which has been filled. And finally, enforcement, particularly on restructuring Copyright Board. Copyright Board was somewhat in a shape, but then it didn't do the job which was supposed to do. There was some copyright restructuring, and then border security measures is another which has been touched upon, which was a vacuum we found. Not on civil and criminal remedies, because the law got reasonably updated in 1992. So roughly these are the gaps which one could see which the law was addressing. Then you have conflicts. These are provisions available in the Copyright Act, but then generated quite a lot of conflict by virtue of interest that has been developed by different groups. The most important was access to works for communication to work. This is an industrial conflict. Version recording was one major industrial conflict that has been brought to be addressed. Broadcasting was another conflict between the right holders and the new industrial growth, which we have seen after opening up. It was private broadcasting and licensing of private broadcasting that led to that conflict, which was being addressed. Relationship between the creators and the industry, the print media, the music industry, and the audiovisual industry. There exist the balancing provisions in the Act, but unfortunately or fortunately, I don't know how to put it, the legal system distorted it, particularly the judgment of the IPRS, Supreme Court judgment, and the subsequent interpretation and legal opinions given by eminent peoples, including retired Supreme Court judges, which made the conflict worse, which needs to be carefully addressed. These include the coexistence of the right, section 13 and 14 and 17, and the interpretation given, and the balanced contracts, section 19, 18 and 19, existing provisions and the conflicts that emerged. Working a copyright society was another conflict. There were interesting provisions, balanced provisions, I may say, before 1994 amendment, the 84 amendment, 94 amendment, 92-94 amendment, 92-94 amendment made the copyright societies function a little more independently, but it created more conflicts rather than resolving conflicts, which needs to be addressed. Now, roughly these are the conflicts I could locate, maybe few more, but then most important seems to be these conflicts. Now, let's look at what type of principles which has been used for balancing this interest. It's largely my way of looking at the amendments and drawing some broad principles which I could locate. I'll classify them into three basically and then expand them a little more. First is promoting creativity, which include access to works. That's one principle that one could see when the amendments, you analyze the amendments. Second principle is facilitating access, is protecting investment, because you need an intermediary from the creation of works to take it to the market or to the public. That's where the investment comes, where the access makes it. And the third, what would I call the social dimensions of copyright? I would like to put it by the limits of an emerging market economy and the importance of state intervention. The assumption is that the market economy takes care of by itself, but in an emerging market economy, you see a lot of limits and the states start intervening. I'll briefly explain a little more on these principles. Once you look at the concept of access to work, what you see is promoting creativity and enjoyment of work. That's what you see on access, which is one of the basic principles. Access to work protected by copyright, well, free use, right? Access for creativity and access for personal and private use. Affordable access, that is facilitating access, compulsory licensing, statutory licensing, exhaustion of rights, and other related provisions. Access to works not protected under the Copyright Act, protecting public domain to some extent, the issue of term extension, which gives you the principles that went behind, if you look at it, the type of amendments that came when we look at how access has been promoted as one major principle in the copyright amendment. Of course, it remained in the background as a copyright law, but this amendment really spurred it up and then have large number of provisions which reflect this philosophy or principle which gets rooted into the Copyright Act. The second principle is facilitating access, that is making available copyrighted work. When I use the word making available, is to the society. This is pure industrialization according to me. You nurture and nourish the printing and publishing industry, the film and sound recording industry, the broadcasting industry, the internet service industry which is coming up. Now, the philosophy or the dominant philosophy is that rapid industrialization will result access to work for all at an affordable cost. There is no need for an intervention. This is an assumption which I put on a question mark because I always find this assumption questionable. Reasons. The market philosophy, the third, before I move on, is the social dimensions. The social dimensions of the copyright law is reflected in the nature of relationship between the users, that is the consumers, the large group for which the Copyright Act exists, vis-a-vis the creator and the industry. It's a triangular relationship in that sense. Now, affordable access is what the public is looking for. Reasonable return for creative labor is what the creator is looking for. And reasonable return, I put affordable, reasonable, and reasonable on quote because these are all questionable again. Reasonable return for the investment in production and dissemination of the work. What you see is the limit of an emerging market economy in maintaining a harmonious relationship. The entire post-amendment scenario, particularly the 90s and 2000 litigation, is a reflection of the disharmony that existed because the market is immature, if I say so, to balance itself, the conflict and find solution within the market forces and the relationship between these three. The reason for it is an assumption we have. The whole copyright is built on the assumption of freedom of contract. the right has been given to the creator, because the first owner of the copyright is the author. And the author is given the right to freely negotiate with the market players and get his reasonable return. But what we have seen is an unequal bargaining power, the creator and the industry, resulting in imbalances. That's the immaturity of the market forces and the market system which operates. Unlike we look at developed markets like United States or Europe, where you see much more balanced type of relationship that exists. That means freedom of contract is a myth in the Indian reality. Section 18 and 19 amendments, even pre-amendments, are a reflection of it. Because there are quite a lot of provisions that has been built in to find that balance, fine-tuned and balanced. It is also a reflection of the case laws that emerged in 60s and 80s and particularly in 80s, late 70s and 80s. Second, maintaining competition, which is also an assumption that it maintains. What we would see is an availability of an infrastructure and access to work. The new players in the market created more rift rather than balance. The broadcasting industry is a classic example. Radio broadcasting and television broadcasting. And probably we are going to see the conflict with the web-based transmission that is going to take place, the webcasting industry, which is yet to grow. Now, this where the imbalance needs the legislature to intervene. If the market is not behaving, then it's the duty of the legislature to step in and find the right balances. We could see the legislative interventions on facilitating access as well as regulating the relationship. That's the dynamics in which it operated. I'll just illustrate one set of provisions, because there are a large number of provisions where you could apply this principle and find probably. I look at it at a later stage when I move on to sessions and then try to intervene and find out how the balance has been built in many provisions. Promoting creativity, let's look at quickly a few things. The rights of the authors in digital context. You have definitions for cinematograph film which has been reworked. You have a commercial rental definition which has been introduced. A communication to public reworked. And visual recording added. Commercial rental and visual recording are two new definitions that has crept into it, which brings how the rights of the authors has been addressed in a digital context. Along with the amendment in section 14, talking about storage in electronic medium, plus commercial rental and removing resale rights, which was there in the 1992 amendment. Which reflects the balance the law was trying to build in. The resale rights has gone much beyond what has been expected, so it has been withdrawn, but at the same time there is an updating of the other rights and balancing it with the commercial rental, replaced with a definition of commercial rental, and finding out how commercial rental can be balanced with what you call rental. That means giving by the libraries and other institutions for renting. We'll also see performance right, which is also promoting creativity. The imbalances which the law maintained between the creators of copyrighted work on the one side and the performers of the copyright one gets updated in 38A. And the balance the law is trying to do is expanding and facilitating free use in the digital age. You have coverage of all works, which is a major breakthrough. Let's look at section 52. Completely, wherever the works has been put, has been made all the works, because it addresses multimedia works rather than works literary, dramatic, musical, artistic work, which is increasingly getting blurred. It's also going to be blurred when the transmission takes place in the internet, which we have seen already. Private and personal use, storing in digital media, the explanation you have on section 52.1 and the rewording of section 52.1 also reflects how it takes place. Digital storage by libraries is a revolutionary provision. I don't know how many of you have noticed it. It's much broaden it up. The libraries are free to digitize and do it for their own purpose. Much, much broader provisions we included. Unfortunately or fortunately, we have not touched the educational provisions which need really updating. But then it left as it is. Probably the legislature thought it has broader space to accommodate it. We need to find out how the Delhi High Court is going to react. Use of persons with disabilities is the balance which built in. And then transient incidental storage and responsibility of the service providers. You could also see simultaneous amendments on compulsory licensing provisions, again broadened to all works, right? And broadcasting is a later entry. It started with radio broadcasting and it moved into broadcast and television broadcasting as well. You could see all the three principles which I was trying to explain operating when you look at these three amendments, three sets of amendments simultaneously, and ask the type of balance which the law is trying to make. What makes me very interesting is the role played by the interest groups and the impact it has on the balancing exercise. The industry groups are the one who played the dominant role, which makes it very clear that copyright is no more the right of others. It's the right which has been run by the industry group as owners. Now the film and music industry were the forerunners to begin with. It started with expanding the rights and preventing abuse, particularly on cover version. This was where it started with. The broadcasting came in after some time, because when the amendment process was going on, the broadcasting ministry started giving license to radio broadcasting without simultaneously looking at what exactly is the provision in the Copyright Act to facilitate access for broadcasting. It's really resulted in conflicts. Practically, they went into copyright board on the one side. To me, the amendments tilted the balance depending upon the economic and political power of groups. If there are imbalance in the amendment, where our balance has been killed, it is this pressure that really made the tilting. If the language is distorting, if the language is not giving the right clarity, if the words used are not appropriate, I believe this lobbying with both economic and political process had a tremendous impact. Well, conferences being organized, ministers are invited, books are released, articles are written, or the process through which the whole process got activated, particularly after the amendment has been tabled before the Parliament. Now, in that process, you could see two very important missed opportunities which reflect the powerful lobbying. The first is what the Vice Chancellor was mentioning of the provisions on the director of the film. We have the provisions which has been added, which has been deleted. And look at the observation of the Standing Committee. The Standing Committee says that this provision will kill the film industry. And the same Standing Committee said, if there is absence of provisions for lyricists and music composers, it will not nourish the industry. That shows the conflict. Because both are players in the film lobby. But on the one side, the Standing Committee took a view that it will kill the industry. On the other side, the Standing Committee took the view that it will make the industry grow. That shows the lobbying power which we see. That's the impact of lobbying, I may say. Second provision is the provision on exhaustion of rights, which was there on the table. And look at the observation of the committee. The Standing Committee said it's a public interest provision and it has to be protected. At the end of the day, you saw that being withdrawn. It's again the impact of lobbying, which makes the provisions balanced or imbalanced. Now, let me quickly move on to challenges of implementation, because this is what I want to throw open. The most critical in terms of implementation is the relationship of authors and industries. The amendments introduced in 18, 19, and 17, 18, and 19, read along with the amendments introduced on copyright society. Let me list the type of conflicts that possibly we will examine. One is the application of the new law.
Is it going to be applicable to new works, existing works, or both? The Act is really silent. It gives sufficient space for one to look at how new rights and new amendments apply to others. Second is the validity of existing contracts and its enforceability. There are a large number of contracts which has been entered into, particularly in the context of the Copyright Society and its functioning, the members of the Copyright Society and the type of conflicts. What exactly is going to be the validity of the contracts with reference to future exploitation works are concerned? First and second are correlated. There seems to be legislative directions, but one could read clarity or lack of clarity to those provisions. That's what is going to reflect when it gets into implementation. Third, new contracts and royalty. There is a major issue with reference to one-time payment, and one-time payment being considered as royalty flow. There is a deliberate legislative intervention on Section 18 in the beginning and new provisions in 18 and 19 which makes it very clear that in addition to the payments you make, there must be royalty, which asks us to find out the new meaning of royalty in the context of amendment. Is it a periodic return, or is the law going to be interpreted by saying that even one-time payment is also a royalty and there needs not be a flow of royalty as long based upon the returns which has emerged on that. Fourth, ban on assignment of right to royalties and the validity of that ban. There is an express provision which says that you cannot assign the right to receive royalty, particularly in case of film and sound recording. Is that going to stand the test? Is somebody going to challenge it by saying it's violation of my right to assign? And if that violation, that question comes up, how is it going to be interpreted and understood? Mandatory sharing of royalties, which you see with reference to film and sound recording between the producers and the creators, and it says that 50-50 in some occasions. How is it going to be implemented? What type of challenges you face when you actually get it into reality in terms of contractual relationship? There is also a provision which says that only copyright societies can license works that got incorporated into film and sound recordings, which also needs to be read in the context of Section 19 and needs to ask the question, how is it going to work in terms of implementation? You may litigate the alumni throughout and get lost. Maybe one way of looking at it. I mean, the rift between the others and the industries. Or you may breach the relationship. Good industrial practice by developing balanced contract. I look forward for the second rather than the first. I hope the industry will mature, the market will mature, and we'll understand that coexistence of the creators and the investment is the fine balance which the law is looking for. And that fine balance is not absolutely through a litigating process, but through building confidence between the players within the market, and then see that there is better contractual relationship built that takes the industry forward, make the industry grow and flourish. Second set of challenges is coexistence of various rights. Copyright, creators and producers is blend with Section 18, 19 amendment. So Section 13, 14 and 17, the distorted amendment of the Supreme Court in our IPRS case, and how it is going to be reinterpreted. Is somebody going to re-challenge it and then find it working? Coexistence of copyright, performance right and broadcast reproduction right, because of the provisions we introduced in Section 13, 14, 17 and 39A1 proviso and 39A2, which is also trying to find the coexistence of the copyright, because they say it should not mutually conflict each other. One must respect the other when it is looked into. Something which one needs to look at how it is going to be implemented. Duration of photographs is something which is crept in as expansion of the term of protection. One needs to ask the question, the problem of identifying the photographer. It was only a 25-year period. So it was from the date of publication for 25 years. Now it's life of the photographer plus 60 years. So if you don't know the photographer, what will you do? 95% of the photographs are without the photographer's name. There is absolutely uncertainty in the law in terms of risk. Probably a missing which needs to be addressed in terms of implementation. Statutory licensing, there is an interesting situation. Performance right has been added and strengthened. But if you look at the statutory licensing and Section 38A, there is no reference to Section 31C and 31D. Is the statutory licensing issued for copyright work can be enjoyed minus performance right being acquired? It's something very interesting for one to look at it and ask the question how it's going to work. Fixing of royalties on cover versions in digital context, because the media has been used, the terminology of the word media has been used. The last medium in which it has been published is the medium from which the cover versions can take place. So the Copyright Board has a tremendous challenge of fixing it. On broadcasting, also the Copyright Board has a challenge of fixing the royalties on radio and television. We need to understand how the royalty rates needs to be fixed, and because that brings the possibility of implementation of these provisions meaningfully. Coverage of simultaneous and webcasting. Simulcasting and webcasting is an interesting concept because the word used is radio and television. And then we see both movement into simulcasting as well as webcasting. There is a conceptual difference between broadcasting, simulcasting, and webcasting. The law has not addressed clearly the notion of simulcasting and webcasting. It still remains with broadcasting. So it's an interesting question of how the notions of broadcasting and webcasting and simulcasting is going to be brought and understood in the context. Are the codes going to be crazy or are they going to be balanced? I'm worried about the codes all the time. Protection of service providers. There are certain concerns which I see, particularly the lack of addressing the overlap between the IT Act on the one side and the copyright on the other side. In addition to the overlap between Section 51(1)(b) and C, meaning of the word electronic transmission which has been used in B and access that has been used in C, and how you read it together to make sure that automatic transmission get exempted, whereas it's only human intervention possibilities of access get covered under C, because B is supposed to be free, where there is no intervention. C is supposed to be where the reasonable care needs to be taken. So how it is going to be understood is something very interesting. It was very difficult at some point of time to understand the technology and the movement of technology, particularly the fast growing nature of the technology on that. Functioning of copyright society, let me list the conflicts, the relationship between author and owner. That's the right owners and the industry ownership. The word used is author and other owners of right. Control, management and sharing of royalties. That means the copyright functioning needs to be restructured reasonably, and it needs to be more carefully looked at. Re-registration and settlement of dispute on royalty payments based upon existing agreements is a great challenge, because if you want a re-registration, the law makes it very clearly that there must be a clean sheet from the members by saying that there is no dispute that exists. It's something which one needs to look at it. Issue of license for literary, dramatic and musical and artistic work included in film or sound recording, because it can be done only through a copyright society. Is the author's right on the one side and author's freedom to license on the one side. And the legislative mandate that this has to be based upon society, how it is going to work is interesting. Transparency in functioning of the society is something which is also interesting in terms of implementation. Now, what we have seen is a monopolistic tendency from the copyright society. This is very visible between the litigation that went into by the broadcasting industry on the one side and the copyright society on the other side. And how are you going to address the issue that the copyright society won't become monstrous? They are not supposed to be. But then they can also become a problem in terms of access. Now, border measures, overlap between customs rule and the provisions we have kept in, because customs have brought out a specific rule with reference to intellectual property, border security measures. We have an express statutory provision which talks about how border security measures has to be addressed when infringing properties are brought under a Copyright Act. How is it going to be worked? After all, at the end of the day, it is the customs officials who are going to enforce it. Now, protection of technological measures, we have 3 interesting concerns there. One, the meaning of effective technological measures applied for the purpose of protecting the rights. How is it going to be understood and interpreted? Effective. What we mean by effective? The law kept it deliberate, seems to be deliberately free for the technology to be understood. And it is to be applied for the purpose of protecting the rights. And second, proof of circumvents with the intention of infringing such rights. These are 2 practical questions that the courts has to confront with when you are implementing it. In addition to facilitating circumvention to enjoy rights under Section 52. We have an exception under technological protection measures which allows third-party intervention for facilitating circumvention. How that's going to be implemented is also an interesting scenario. Now, broad opening up, let me conclude by 2 or 3 major observations I have. The challenges of balancing of interest in a fast-growing economy. The entire amendments witnessed this challenge. It's not easy. It's much easier to have a stable economy to find the balance, because the people who play in the process are mature enough and there is more balance in the pressure groups and their play in the process of lawmaking. What could one see is an imbalance in their role they have played. So once there is an imbalance on the pressure groups who work behind the process of amendment, you could see many challenges because of the immaturity or the growing nature of the industry. The industry, the tendency of the owners of the right to hold on to the maximum when they get the right in, to prevent competition, which facilitate growth of industry, particularly middle level and lower level industrial growth, which is the strength of an economy in its totality, which generates more employment and more opportunities. There is a resistance. Cover version is a classic example. Cover version was an industry worth 1,000 crores or whatever it may, or 10,000 crores or whatever it may be when it was being litigated. 5 years is the duration which has been given for the purpose of cover version to be made. One needs to seriously ask the question, what is going to be the status of cover version industry? What's the job losses we are going to face? How is the new creativity going to be promoted? Because new talents are the outcome of the cover version industry on that. It shows the tremendous challenge which has on the economy. Second is the importance of social issues in a digital context. Print media and visual media had an inbuilt mechanism of finding out the social concerns. But then digital technology opens up new social challenges of unprecedented nature. So how social issues needs to get reflected, particularly when you address amendments in a digital context. And third, refocusing of copyright law, projecting access to information. Copyright law seems to have taken a back step at some point of time to strengthen the rights, and the assumption that strengthening the rights will automatically facilitate access to information. What the amendment has shown us is that there needs to be a deliberate legislative intervention so that the copyright law gets a refocus on projecting access to information. The challenge is promoting industrial growth without sacrificing social interest. You have a terrific social interest, particularly in terms of access to information, promoting creativity, encouraging talents, and access in a country which is substantially people who cannot afford on the one side, and a pressing demand of the industry in a globalized context. The industry is facing terrific challenges from unprecedented, powerful industry groups, be it in the printing, where you have foreign direct investment, or in equity participation. Look at the challenges you have on broadcasting and ask the question of the challenges the domestic broadcasting industry face in the context of globalization. Well, you can also take the same thing in the internet context. So it's a pressure on industrial growth on the one side and the social interest on the other side. That's a great challenge which one sees on the whole through process. Thank you very much.